Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
This is Serious Privacy by TrustArc. Here are your hosts, Paul Breitbart and Kay Royal.
Last summer, we were all surprised by the sudden adoption and speedy entry into force of the Chinese Personal Information Protection Law, the omnibus data protection law that covers all data processing in the People's Republic of China and targeting their citizens. A lot of details surrounding this law remain unclear, but we have recently seen some clarifications as well as the start of enforcement of the law. For that reason, a couple of weeks ago, TrustArc organized a webinar providing an update on PIPL. Because it has been quite a while since we last told you about this law, Kay and I decided to provide you this week with the audio of the webinar. We did not use many slides, so you should be able to follow along easily. It is a bit of an experiment though. We have not released webinar audio for a long time, so please do let us know if you want us to do this more frequently. As always, my name is Paul Breitbart.
And I'm Kay Royal, and welcome to Serious Privacy.
Before we start, let me introduce you to the third speaker in the webinar, TrustArc's Yi Lu.
Hi, good morning for people in the Pacific Times. My name is Yi Lu. I'm a global privacy manager here at TrustArc. I work on privacy certifications with a lot of companies here, including Chinese companies. And then before TrustArc, I was a policy researcher at a corporate think tank in China, and hopefully that provided me with a little bit more insight into PIPL. I'm happy to be here to share what I know, and I look forward to the discussion.
And don't forget, Yi is a licensed attorney. So she has been an incredible resource for us in understanding and deciphering, trying to guess where the PIPL is going, especially when it comes to some of those cultural nuances that you kind of have to be in China to understand what those are meaning.
And now, without further ado, and unfortunately no unexpected question, let's listen to the webinar.
So today we're going to cover a brief overview of the PIPL, latest additions to their legislative framework, frequently asked questions. And if we don't have your frequently asked questions already in our frequently asked questions, we are absolutely delighted to expand that knowledge for you. The enforcement mechanisms and potential fines, your next steps to quickly ensure full compliance with PIPL, and how to leverage the privacy work you've already done to be compliant. So with that, for the PIPL overview, I'm going to have you start, Paul, and then I'm going to quickly move to E for the latest additions to the legislative framework.
Yeah, absolutely. So let's start indeed with the overview of PIPL. Yes, I am consistently calling it PIPL to facilitate the pronunciation. Not everything is always not always has to be spelled out. This is a continuous battle between Kay and myself, by the way. So don't get worried about that.
We'll see what E says.
So when we look at China's personal information protection law, because that is what we are talking about, we are basically talking about China's equivalent to the GDPR. And I think it's fair to say that a lot of us, especially here in Europe, are looking at PIPL the same way that many people around the world were looking at GDPR when that was adopted back in 2016. What is this massive new law that we have to deal with? What does it say, and how does it fit into all of the other regulations in that jurisdiction? And I think that is especially fair for China. GDPR still had the advantage that it was available in an official English version, whereas for PIPL, we only have the informal translations. There is no Chinese government English translation of this law. Luckily, the informal translations are largely similar, so we do have quite a good grasp by now on what it means.
And I will say that on part of the translation, so for example, when I mentioned the nuances with China, E was able to help us with this when one of the definitions, and I know you're about to get to sensitive information, is they had a category, specially designated statuses. And it was translated into various terminology, and Paul and I could not narrow down exactly what that meant. And the translations available to us were not able to do so either. E came to the rescue and was able to share with us what a specially designated status was. And so that was very, very helpful. And that's exactly why she has been an incredible resource for understanding PIPL.
Absolutely. So yeah, when we look at the scope of the legislation, again, it is fairly similar to the GDPR. PIPL applies, first of all, to all the processing, or as it is called under this law, the handling of personal information of natural persons within the borders of the People's Republic of. That makes a lot of sense. But also processing, handling of personal information outside of China on individuals in China is covered by PIPL if one of three conditions is met. First of all, if the purpose is to provide products or services to natural persons inside the People's Republic of China, where analyzing or assessing their activities, and also for other circumstances provided in laws or administrative regulations. That final formulation is something we see a lot in PIPL. There is a lot of cross-referencing to non-specified other laws that exist in China, and that is probably also the most difficult part of the whole compliance with PIPL. If we look at the overall criteria, of course, processing in China, offering goods or services or offering products or services, and analyzing or assessing activities, monitoring the behavior of people is something that I think we've all been fairly accustomed to based on GDPR and also some other data protection laws around the world. But what those other laws and administrative regulations may say might be difficult for us to find out here in the West. So we try to keep track. There is nothing yet that we have found out that would be covered by these laws, but of course, there may be new proposals coming forward also in the 14th five-year plan that was just proposed by the Communist Party of China. When we look at the handling sensitive personal information, there are quite some additional obligations to bear in mind, because sensitive personal information, again, very much like the GDPR, may only be processed for specific purposes and needs, and only if it is very well protected. So it is any information that, if it is leaked or illegally, can cause harm to the dignity of natural persons, grave harm to their security or the security of their property. And that means that you, for example, need to be careful when it comes to biometric data, religious beliefs, indeed, the specially designated status, medical health, financial accounts, individual location tracking, etc. So also here, there is no strict definition of what is contained by sensitive personal information, but anything where you process it where it could be detrimental to the individual, I would say, can be covered by this definition. So here there is, for organizations, a strong responsibility to also document why they believe the data they are processing falls or does not fall within this category.
And with that, Paul, there may be people out there who are wondering, what is the definition of specially designated status?
Exactly. I was just going to go to Yi for that because I still struggle with that definition.
Yeah, E, I'm sorry I'm putting you on the spot with this one. This wasn't a question I had noted down. I was coming with you, but do you recall what the specially designated statuses were?
So for one example, like for criminal penalties, there's one thing that could happen is that people get rid of their voting rights in US context, but in China, it's called political rights, like that you can get elected as a government official or it's just your voting rights. So if that person has been taken away that kind of rights, that is considered as a specifically designated status, just as an example.
Yeah, and I think one of the other examples you gave back when we were discussing it that really stuck with me, I know it's not the only example, but the one that stuck was someone who had a job that if you leaked what their job was, it might actually endanger them, such as cops working undercover or intelligence. So if you think more along our Snowden leak, where it leaked a lot of information about individuals, that would also be considered a specially designated status.
Correct.
Okay. Beautiful. Thank you.
If you want to process all of that sensitive data, you will need consent under PIPL. There are more legal bases in the legislation than just consent, but for special categories of personal information, you will need that consent, and you will also need to provide proper notice. Basically, anywhere in the world, consent means that you have freely given, well-informed, is an active choice of the individual, and it is not just required as a legal basis for many data processing operations or for some international transfers, but it is also a requirement when it comes to cookies. Cookies as such are not explicitly mentioned in PIP, but they are covered because the legislation says that when it comes to, for example, online data, that you would need consent, and also that what we consider to be first-party cookies, first-party information, that those would be exempt. So first-party or information that is strictly necessary, I believe, is the formulation to make online activities function. Those would be exempt. For the rest, indeed, you would need a cookie consent. Okay, you want me to continue with the cross-border data, or is that something that you want to pick up?
Cross-border data transfer is fine. I think E is going to give us a little bit more information to that. And I know we're going to cover enforcement later. So just quickly for cross-border transfer, it is not clear at this time, and E, please correct me if I've missed new information, that data that is processed within China but accessed outside China, it is not clear if that's a cross-border data transfer yet, which under the GDPR would be a clear data transfer. But under the PIPL, it seems like the government is interested in maintaining the Chinese data within China. And so a cross-border access may not be considered a transfer. Any elaboration on that, E?
Well, with the two newest regulations, access from a foreign data processor might also consider a transfer under a PIPL context. We will talk about that in more details when we talk about the new data security management certification rules, as well as the technical specification for certification of cross-border processing of personal information.
Ah, beautiful. So, Paul, do you want to dive in a little bit? I know we're going to cover enforcement later, but platforms and corresponding obligations, or do you want to just talk about that when we get into more of the details?
No, well, I think it's good to mention that indeed the larger platforms, as they are called, important internet platform service, that those have specific requirements. And then we are really talking about the very large companies, so the Alibabas of this world. And they will, for example, to establish extensive compliance. So they need basically a similar system in place as if an American company would have CBPRs or a European company would have BCRs, a whole documented compliance program that also meets the standards of the Chinese state needs to be in. Furthermore, they need to establish their own independent supervisory body that is composed of outside people, so they cannot be employees of the company. I think that's very comparable to the role that I'm currently fulfilling at the European Patent Office. So really as an external party being mandated to supervise data processing within one specific organization. And of course, they need to abide by all the rest of PIPL as well. They need to abide by all the principles, so openness and fairness and justice, but they also need to formulate very specific rules for their platform. And they need to regularly release personal information protection, social responsibility, and also submit to society supervision. So also deal with complaints from society, and they cannot just push those aside and say, oh no, but that's not important. So also their company should submit. This is to some extent, I think, comparable to what we will be seeing in Europe under the Digital Markets and Digital Services Act with the requirements for the very large online platforms. It is also something that we'll see in India in the legislation that's being brought forward there in Congress, and maybe also at some point in the United States, where there are also discussions on additional rules for big, because that is basically what we're talking about. And they will be held to higher standards because they have so much market power, so much data under their control, that they also have higher reporting standards and higher compliance with the legislation.
Absolutely. Okay, so with that, let's move to the latest addition to the legislative framework. So, E, will you take this away?
Yeah, sure. So just as a very unique thing to Chinese legislation, when the draft first come out, it is not unusual that we'll say the concept is there, the law is there, but the law actually leaves a lot of ambiguity or gaps to be filled in. And then in practice, we will see technical specifications, guidelines, new regulations that work to fill in those gaps. So luckily for PIPL, we do see a lot of additional new guidance since the end of last year. And this year, a few of the latest edition that really worked to clear ambiguity for PIPL. One is the privacy notice requirements for internet platform product and services that published late May. And then the other two that we are seeing is the certification requirements for cross-border data transfer and also the draft technical specification. That's also coming in early May. And then the other certification requirements is effective immediately. So I would like to talk about the privacy notice requirement first, because that one is more straightforward with more guidelines and also compliance details. So the privacy notice requirement, it serves as a guidelines for organizations to get compliant as the PIPL, as well as other lower level regulations. And it also mentioned that this is what the regulators and evaluation agency will use as a standard in assessing compliance for internet service operators. So this new regulation, it touches on a couple of things. First, it requires certain procedure to be in place for companies when they're drafting their privacy notice. So first, companies need to have a complete personal information security management system. They need to define a clear owner or department that's responsible for drafting the privacy notice. They need to identify the person in charge to make sure that person will support the drafting of the privacy notice by gathering the correct resource within the organization and also maintaining the security management system. Secondly, the new law requires to identify the scope of the data collection, ensuring that the collection is fair, legal, and necessary. So the privacy notice requirements specifically referred to a regulation called Mobile Internet Application Necessary Data Collection Rules. So that law actually specifies a very detailed scope of what is considered necessary data for different service types. So for example, if you are a ride-hailing app, then what is considered necessary is your name, your contact, your address, and your location. But if you are for example, then in the ride-hailing app, it's not necessary if you collect either ID type, or ID numbers. But if you are a financial kind of app, if you are collecting people's ID number, photo, that is considered necessary and allowed. So the third thing we required when drafting the privacy notice under this regulation is to have a security assessment if the processing activity will significantly impact the data subject's interest. And what we need to do in the security assessment is to identify the purpose, scope, and method of data collection, and also the individual's rights and interests and how to protect those rights and interests. Also, what is considered significantly impacting individuals' rights of interest is if you're processing sensitive information, if you are having automatic decision-making process, or if you're processing on behalf of another handler, disclosing personal information externally, or you are doing cross-border data transfer. So we can see the philosophy under this law is completely consistent with PIPL and other relevant laws.
Right.
What is also included in this mechanism is that they also require data processing report, which needs to identify the data type that you collected, the storage of those data collected, a mapping of the data transfer, as well as the owner. And then lastly, in the drafting process of the privacy notice, a DSAR mechanism needs to be considered and also established. So that's the first part of the requirements.
All of that which resonate well with people who are already running privacy programs.
Exactly.
Yeah.
And then the second part of the privacy notice requirement has very specific details on how to have a compliant privacy notice. So what is new is that they now specifically require a summary section of the privacy notice to be placed at the beginning of the privacy notice or as a separate document. That is now required. The philosophy is that this will be a shorter text that allows audience of the privacy notice to understand how the information processing activities work in a very quick and straightforward way. And then another thing that's specifically required is a personal information collection list. So based on the different service type of your product or service, the data handler is now required to list all necessary personal information collected and as well as unnecessary personal information collected with the explanation of why they're collected.
Okay.
And then another new requirement is that if you are going to update or revise your privacy notice and it creates significant impact to individuals' rights or interests, the handlers shall make proposed revision available on their official website for at least 30 days to allow for public comment. And then they need to provide explanation of why public comments are considered or not.
Oh, that's interesting.
Yep. And there comes additional requirements for large internet platforms. So large internet platforms are required to seek advice when they're revising their privacy notice from outside independent committee when doing this process. And large internet platform with daily active users of over 100 million should pass third-party assessment carried out by agencies designated by State Department and also submit the final privacy notice revision for approval. So that's a lot to do when they're trying to update privacy notice.
Oh, privacy notices are already so complex to try to get them updated accurately based on your data inventory and your processing activities. And now to have to go through outside third parties, advice and comment period, almost like rulemaking. That's going to be interesting.
Yep, that's a lot of obligation on the platform side.
It is. Okay, talk to us about, if that one's done, then let's talk about certification requirements.
Yes. So this certification requirements, we do understand it as directly addressing the certification regime for cross-border data transfer.
Okay.
So for now, when we are processing cross-border data transfer, there are actually two levels of requirements that we're looking at. First, the hurdle is that the processing activity is truly needed, as Paul mentioned just now. And then second, under Article 38, we need to meet at least one of the four requirements. So the first one is the government security assessment. So this one will look at the draft data export security assessment, which was published earlier, but it's mostly required if you are a CIIO, a critical infrastructure information operator, or if you're processing critical data, or you're processing data of over 1 million individuals. So that part is actually discussed a bit more in cybersecurity law rather than PIPL.
Right.
And then the two new regulations address is the certification regime. That is the second requirement for one of the second requirement for the cross-border data transfer. So when we are looking at the certification regime, it applies to two kind of scenarios. One is if you're a multinational companies and you are trying to process data to your either headquarters outside of China or your office outside of China. The other scenario is that if you are a foreign information handler and you're trying to either access information within China or processing that information about Chinese individuals. So under the new law, let's see, we have two. And then when we are talking about the draft technical specification of certification, that is kind of like the standard we will look at when we're processing the certification process. So there are a couple of basic requirements when we assessing a cross-border data transfer. First thing is to have a legal binding documents or say contracts that specify parties involved in the cross-border data transfer, the category of the data in the process, the scope of the data involved, the purpose of the processing activities, the measure to protect individuals' rights and interests, and also the share rules that the parties involved in the processing activity had agreed on. And these share rules, as well as the provisions in the contracts, need to meet at least the same level of the PIPL compliance.
Okay. So a lot like standard contractual clauses.
Yes, that's what a lot of people would think.
Yeah. Okay.
And just for us Europeans, this is effective as of 5 June, right? And not
the June. I'm confused right now. It's actually June. So June the 5th.
Okay. Long live the international date format.
That's a good thing to point out. I love it. Okay. Anything else on this one about the latest editions that actually provide a lot of clarification to some of the unanswered questions we had?
Yes, it does. It only answers the question under one regime for the cross-border data transfer, but that is also considered the most promising route for now to process cross-border data transfer.
Beautiful. I love it. Lots of good information to be able to guide us. So with that, Paul, let's move on and talk.
You want to talk a bit about enforcement, right?
I wanted to move into the enforcement mechanisms and what we're looking at. I want both you and E to speak to that. But then also, if we have any questions that are coming in, like this one that just came in, can the EU standard contractual clauses be used to fulfill the cross-border data transfers? They should be able to fit. I know we just glossed over that quickly, saying that maybe you could use the standard contractual clauses. In your opinion, do you think the standard contractual clauses would fulfill the PIPL's requirements?
I think what the Chinese legislature are trying to do is to come up with their own version of standard contractual clauses. So for the 4 requirements, the third requirement is that you can utilize a contract with foreign data recipient that aligns with the standard contract provisions formulated by CAC. So that provision is coming, but it's not yet available.
Do we have any idea when that's coming?
No, not at all.
I was waiting with bated breath.
I think it would be too optimistic to say that China will indeed just accept the European standard contractual clauses for data exports out of China, if only because they do not align in full with PIPL. So I think that we will see situations that we also see in other jurisdictions, that they will develop their own standard contractual clause, maybe draw some inspiration from the setup by the European Commission, as we've also seen, for example, with the standard contractual clauses that have been developed for the UK, in New Zealand, for the Asian countries, so the Association of Southeast Asian Nations, and also from the Council of Europe. They are all very much similar, with similar requirements, similar assessment procedures before you can use them, but all of them are also slightly different. And I think that will also be true for any SEC standard contractual clauses, model clauses that we will see out of China. My one hope is that at some point, more jurisdictions will follow the precedent set by the UK government, and that is to create an addendum that can be used as a sort of converter for other standard contractual clauses to align them with the national framework that is in place already. So, for example, if you already have EU standard contractual clauses in place and you also need model clauses to export data from the UK to a non-adequate country, you can use the UK data processing addendum on top of your EU SCCs to transfer the data in a legal way. And it would be great if all jurisdictions would come up with similar addenda that can then be used. I think that would make the life of lawyers quite a lot easier and the stack of contracts to be signed a lot lower.
Yeah, and we've already seen global companies trying on their own to work these provisions into their contract. And not just for China, not just for the EU, not just for the UK. There's cross-border data transfer requirements in like nearly 100 countries. And many of them can be fulfilled by consent, or they can be fulfilled by contract, different things like that. So there's a lot of overlap into the allowable mechanisms. The difference is in the details within those mechanisms. But we see a lot of companies now trying to say, and in Switzerland, you do this. In China, you do this. In Brazil, you do this. In Colombia, you do. So it's really interesting to see how we're all trying to come up with our own formulation of how to meet these requirements without having a global contract be, 150, 200 pages long. So yes, it does make for consistency for the privacy office, which is, we all know consistency breeds compliance and compliance breeds trust. So we're all looking for those consistent mechanisms that make our lives easier, but also makes the compliance better for the end users and the people we're actually protecting. So let's move on then and talk a little bit about enforcement. So Paul, if you can start us off with what enforcement is provided for under the PIPL. And if you notice, E said PIPL too, just say.
So the enforcement measures under are extensive because there are actually a lot of supervisory measures that can be, can be civil, they can be criminal, and can, for example, include, because also here we do not have a limited list of options, but they can include compliance orders, they can include processing bans, they can include confiscation of unlawful income, and of course also fines. So the fines are divided into, I would say basically 4 categories. You have fines for regular contraventions and very heavy ones. And then you have the personal sanctions, the personal fines, and also the personal fines for very heavy contraventions of the law. So for a regular violation of the law, a fine can go up to 1 million yuan, which is about $150,000. They can, for grave violations, go up to 50 million yuan, or about 8 billion, or 5% of annual revenue, where the GDPR maximum is 4%, and I believe the Indian maximum is set to 2% if the law is adopted. So it's 5% or the 50 million yuan. And for individuals, the fines for regular violations are between 10 and 100,000 yuan, and for grave violations up to 1 million yuan. And then in addition, individuals can also receive a sanction that they can, for example, be prohibited to fulfill certain functions for a duration of time. So for example, they cannot be a DPO, or a personal information protection officer, as it is called under PIPL, for an X amount of time. And also there is a possibility that violations will be reported to both the individuals and the organization's credit files. And so that is when it comes to the sanctions. But the whole range of sanctions is, of course, much larger than just the fines. And also, if you look at at PIPL, at the Chinese legislation, I think the aim in the end is still to move towards compliance. So the fines are there as a last resort option, but there is a whole range of other options that will push the company and the individual towards clients.
They also build in criminal repercussions if you violate a law that provides for criminal violations. So they do allow for that in the PIPL.
Yeah, those are there, and that is fairly specific that is mentioned. It is not unique to impose criminal sanctions to people who misuse data processing. We've seen that in multiple countries around the world already, including in the EU, even though it is not explicit in the GDPR that an individual can go to jail for processing personal data illegally. Then usually that is based on other grounds under national law. But it is indeed a possibility, and also good to mention, especially right now, while in the US a hearing is ongoing on potential federal law, there is also a private right of action.
Yeah, exactly. So one of the things that's quite often up for debate here in the US is whether or not there's a private right of action. So that's interesting as well. So what would you be able to add into this? Have we started seeing any enforcement action or moves towards enforcement action in China?
Yes, we do. So I want to elaborate a little bit on the compliance order. I think what we see as an example similar to that is investigation or inquiries initiated by the regulators, including the Ministry of Industry and Information Technology, the MIIT, as well as the National Administration of Market Regulation. So the way they do that is either they reach out to companies directly, or they will publish a list of violators, quote violators, on the official website, which contains the name of the internet service providers or apps and what they consider as a violation of PIPL. And they will give out a certain timeline for these companies to correct their wrongdoings. And then if companies fail to remediate those gaps when the timeline's done, they will either face fine or suspension of the products from either like App Store or the website.
Now, how long do we expect the timeline to be?
It's either 3 months or 6 months. I believe
3 or 6 months. Okay.
A lot of timeline that we are seeing right now.
Okay. So decent time to be able to cure a violation.
Yeah. And we do see like mid to larger size of companies, they're faster in responding to this kind of request. And then smaller companies or smaller apps tend to stay a bit longer on that list.
So how many actions do you know of that
I think it's around 6 to 10, and it's still ongoing.
And I know the last time that we had a webinar on the PIPL, we were thinking there were enforcement actions coming. However, it was also during the time of the Olympics. And so we all kind of felt that we wouldn't really see enforcement actions until after the Olympics.
Yep. I would think like the time window between that's a bit longer, but we do see more upcoming inquiries this year.
Okay.
So yeah, when we looked at the end of last year, when the law came into effect, we were still debating whether the main aim of the Chinese authorities would be to focus on local companies or on international companies doing business in China. And so far, from what I've seen, it seems that the Chinese companies are first on the vision, or on the desk of the regulatory authorities, and that for now, at least, the international companies have been excused, maybe to give them a little bit more time to get ready. I don't know. Maybe we see some sort of an informal grace period here, but I don't expect it to stay that way.
Yeah, Paul, I agree with your rationale. I think there's enough going on for domestic companies because there's like thousands of the apps, internet service operators out there, and also like large companies that's big moving targets. So that's already a lot going on there. And I agree there's like this informal grace period for multinational companies or foreign companies.
Interesting. I hope that continues in a positive direction, because based on the clarity that we need under a lot of the provisions, a lot of multinational or global companies are struggling with what exactly is expected out of them. So maybe the early enforcements will give them some idea as to more detail required. Some of the newest guidance put out or the requests for comments put out will actually give some more insight into what is expected. Because the worst thing is to try to do your best to meet the requirements of a law, but not actually understand what the requirements are. So, okay, let's talk a little bit more about some of the abilities, as we talked in the beginning about what we would get to, is what would the next steps be for companies to comply with the PIPL? And then I want to get into what similarities are we seeing. We've discussed it as we've gone, but let's discuss it in more detail of how can a company leverage what they already have to build towards the PIPL?
So I think one of the great ways is that if you look at PIPL, PIPL, that there is a lot of overlap with GDPR and with a lot of other data protection laws around the world. Maybe not when you look at the exact formulation of the provisions, but the expectations of what you need to do and what you need to have in place when it comes to your policies and procedures and how you operationalize your privacy program. I think that is very well aligned. If you are indeed one of those important online platforms, those big companies, then you can, for example, take a look at the structures that have been developed for CBPRs and DCRs and see what you could put in place and then map that to the PIPL requirements. But also for a regular compliance program, there is a lot that organizations that do business in China probably will already have done for other jurisdictions, whether it is putting in place your policies and procedures to deal with individual rights that are also fully operational under the Chinese legislation. Whether you filed for an access request in the European Union or in China, in principle, doesn't matter because you will need to find out what information you have and present the individual with that information, give a response. The only thing different is that the timelines vary from country to country around the world. And PIPL doesn't even specify a timeline. It just says you need to do it as soon as possible.
And they expect it to be. And they expect it to be as soon as it is possible for you to do so. Yeah. They don't mean in 60 days.
They really need to make sure that it is fast. When you're dealing with data breaches, it's the same. You need to report more or less immediately to the regulatory authorities. But the assessment on whether or not you have a data breach will be fairly similar to what you are used to in the US or in Brazil or in the European Union. So also there, a lot of the policies and procedures that you have in place will help you to also deal with the requirements under PIPL. Yes, the elephant in the room will still be international data transfer, since most of those options that you have under the legislation have not been fully materialized yet. And certainly not the most common one, the use of model clauses. But for the rest, there is a lot where you can really leverage the work that has already been done in complying with other legislation. And the good thing is that TrustArc has done a lot of the mapping that is publicly available in all of the handbooks that have been released. So you can also learn from those handbooks that are mapped against the TrustArc NIMIDY privacy and data governance accountability framework. How much you are progressing and what gaps you still have. So also in doing a gap assessment from one law to the other, you can leverage that information that is already done and that is freely available.
Right. There's a lot of conversation about the repercussions of reporting an individual or an organization to their social credit score. How important is that in China? I mean, I don't care about my social credit score in China, but how important is that to a Chinese individual or someone who might be subject to it?
Well, it's been a while since I lived in China, so I was thinking about what would be some of the concrete examples. So if you're an individual, you do have your credit file, like when you're involved in all kinds of social activities. And if you are trying to obtain a housing loan, you'll probably have that credit report pulled on. I'm not sure all employers do that, but some employers, they will also look at your credit file. And then for companies, for example, if you were on that violators list published by the regulators and you failed to remediate or correct your wrongdoings in time, that will also harm the company's credit files. If the company's later trying to obtain a business loan, I'm sure that's going to have some negative impact on that process too.
Okay. And not to mention it's a public list, right?
It is. And it's mostly accessible to financial systems. I'm not sure if you're just a normal, an ordinary people, how easy it is for you to access another person's files. But for financial system, I'm pretty sure that they all have access to that.
Okay. So in a lot of ways, it's a lot like the credit reporting system here in the US, where there's credit bureaus and everything, but I don't know if it's the terminology of calling it the social credit score or if it's essentially like a credit reporting bureau like we have. So I know that's a question that I've gotten from a lot of people about the PIPL is how strong of a repercussion is that? And if you are in China, if you're a company in China doing business in China, or you're an individual there, it sounds like it could be a pretty significant repercussion.
I would say so.
Okay. That is something as well. So you work with a lot of companies in assessing their global privacy programs. Of course, I'm not going to ask you to violate confidentiality, but what are some of the commonalities that you are seeing that many companies need to improve in order to comply with the PIPL? What are some of the downfalls?
I would say a lot of companies are worried about cross-border data transfer, including accessing the personal information of Chinese individuals from abroad. So that's where people are being very cautious and keep tracking on the newest regulations as we discussed just now, just to make sure that we are not doing anything that's likely to be considered a violation under PIPL and other relevant laws. And then another thing is that we want people to look at the formality requirements under PIPL. A lot of them, they sound similar to GDPR, but it does come to a little bit more details when we talk about the formality requirements. Well, that's where people want to look and stay in compliance.
So don't take it for granted that just because the title of the section is very similar to another privacy law, don't take it for granted that you meet it. Go look in the details and dig into them.
Exactly.
Okay. And I know one of the things that we see a lot is the explicit consent for processing sensitive data, as well as the explicit consent for cross-border transfer for the individuals. I know that we had a few companies curious about this in the past 6 to 9 months or so. And one of the things that they were looking at was an explicit consent banner, very similar to a cookie consent banner, but an explicit consent banner that one could consent to cross-border transfers, not for cookies, but for data. And two, an explicit consent for processing sensitive data, again, not for cookies, but for sensitive data in general, but it would be a modal or a banner or a consent that would be accessible easily on the website that would facilitate individuals giving their consent.
So when we're talking about effective consent for cross-border data transfer, it does come with very specific requirements. For example, that consent needs to be based on the precondition that you have notified individuals about the forward data recipient, the name, contact of the recipient, the purpose of the processing, the methods, and the personal information categories. So only based on those preconditions will that consent for cross-border data transfer to be considered effective. And then in terms of formality, we do see regulators provide examples in the privacy notice requirement of what would be considered a effective explicit consent. So the new law says it could either be a checkbox or if you actively click on agree, register, send, or dial. So those are a couple of examples that the regulators provided on top of the preconditions listed out in PIPL.
Okay, so this is interesting then, because I like the idea of having the modal that's accessible or the banner that's accessible if it includes those requirements. If I assume it can be an expandable privacy notice that lists out the details that it has, but how else would you anticipate? And I'm asking you to put on your creative thinking because I didn't warn you about this in advance. How else would you anticipate that a company would be able to get appropriate consent that meets the requirements? Because we can't get people to even read the privacy notice, much less go through and agree with what the privacy notice tells them is going to happen.
Yeah, I know. But if it's a cross-border data transfer or processing of sensitive information, I think a company needs to expect they're expected to put in more effort. They need to make it easy to understand and make sure that users do see what they're trying to communicate. So they need to understand it's a standalone consent. It's a different thing. It's the processing of sensitive information or cross-border data transfer. And it stands independent from the rest of the consent that you'd be given to other stuff.
So like typical consents, it can't be buried in with other language. It needs to be stand out. People need to understand that they're actually giving consent to a specific thing, not just, yes, I've read your privacy policy, go away and let me access my app. So I like that. And I didn't hear, and I'm going to ask the question, does it need to be in Chinese?
I think, yes, it does need to be in Chinese. That's also that demonstrates your intent that you're providing your service and products to Chinese residents or Chinese individuals within the border. If it's in English only, it's less likely to be considered that you're providing product services to Chinese individuals within the border.
Okay. Paul, you're shaking your head or nodding your head there. I'm seeing some thought.
I'm nodding there. Yeah, it's for me, it makes sense. You offer goods or services in China, or you want to do business in China, you need to provide notice in at least one of the Chinese languages and probably in multiple, depending on the regions where you do business. And I would assume that in any case, well, I mean, in writing, they are, from what I understand, but you correct me if I'm in writing, they are fairly similar, but you will need to provide that notice in the local language like you would in the European Union or in Latin America. The time is over that you could suffice with something in English if you are an international company.
Well, what if your products are only offered in English? Would you then need to translate just the privacy notice?
Then what would be the added value of offering your goods and services in China?
I was just throwing it out there because I know someone is thinking about this, so we have it. One of the other things that I'll ask about the goods and services in China is when it comes to employees. Are there any specific provisions when it comes to employees?
Yes. So actually, the cross-border data transfer, including the new specifications, does cover the scenario when you are multinational companies and you need to process data across the border because you process HR information. So that is also covered in that scenario, as well as the specifications and certification rules covering the cross-border data transfer.
Okay. What are the exceptions then to the PIPL? And we'll close it out on what are the exceptions.
Well, if we're talking about cross-border data transfer, there is the last catch-all, which talks about other situations that needs cross-border data transfer as required under other law or regulations. In this case, what I would recommend is look at sector-specific laws because there are specific kind of data that is not mentioned in PIPL, but they do have more detailed requirements in other laws. One example would be if you are a smart car manufacturer and we are regulating the data process within the manufacturing of smart cars as well as the use of smart cars. So they divided data involved in that process a little bit differently. I believe there are 4 types of data I mentioned in that smart car regulation, such as the user's data, the location tracking data, and the manufacturing data. So that law specifies certain kinds of data will not be allowed to transfer outside the border of China, or there are specific rules that you need to apply to.
Yeah, maybe before you wrap up, when we talk about international transfers, it's also good to mention that China doesn't rule out that there will be adequacy decisions in the future. The legislation doesn't say specifically there will be adequacy decisions, but there is the possibility that when China has agreed to certain treaties or international agreements, that personal data can also be transferred on that basis specifically. In return, they can also use government decisions to stop data flows to certain countries to reciprocate. For example, if the European Union or the United Kingdom or the US government were to say that China isn't careful about personal data, they can say, well, then personal data cannot flow to China.
Right.
Or from China to the other jurisdiction.
And we can ask for last thoughts now. And in your last thoughts, please address whether or not you think the data protection officer needs to be based in China or not. Paul, I'll go to you to close out first.
Yes, I think it would make sense, if only because of the continuous struggle to help understand what is actually happening in China. I think at the very least, your data protection officer would need to speak Chinese. but ideally also be based in China so that you have easier to the Chinese authorities, and also with boots on the ground, you hear things quicker than just being online.
And boots on the ground is vastly different than what's within the four corners of a page. So close us out then. So what are your last recommendations for companies to comply with the PIPL, including your opinion on whether the DPO needs to be in China?
Well, the PIPL does not specify that the representative of a foreign data processor in China needs to be the DPO. It just said you need to designate a representative to take care of PIPL related matters as well as communicating to the regulators. So I would agree with Paul in the sense that the best practice is to have a DPO in China locally, so you get to hear things faster and you can respond to the regulators faster. But that is not mandatory right now. It depends on the company's resource, whether they want to go with the best practice to have a Chinese DPO locally, or they will start with something less than that, just to have a local representative that understands the language, the culture, and able to respond to the regulators in the most effective way. My last word about what would be useful to stay compliant with PIPL is that if you're interested in tracking onto new regulations or new specifications, there are a couple of websites that I recommend companies to look at. The official website of the CAC, the Cyberspace Administration of China, as well as the MIIT official website, and also the website of State Administration for Market Regulations. Those are where we typically find out the most newest draft of standards, specifications, and guidance.
And on that note, we wrap up another episode of Serious Privacy. If you like our episodes, please rate and review us in your favorite podcast app or on your favorite podcast platform. Do tell your friends and colleagues about us and join the conversation. Find us on LinkedIn, just look for Serious Privacy, or via Twitter at @podcastprivacy. You will find Kay on Twitter as Heart of Privacy and myself as your old Paul B. Until next time, goodbye.
Bye out.
That was Serious Privacy.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data, and get credible, cited answers based on NIMD research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.